So I request Mr. Kunal Sarpal sir, founder and CEO, White Collar Legal LLP India, to start the session.
Thank you, madam.
Hello everyone, good afternoon. Can you see me and hear me? This is a check.
Yes, sir, you are visible.
Okay. So first of all, thank you very much for the invite. I've been associated with DY Patil for more than 3 years. Dr. Neeta and I started the association and it went on. A lot of students got mentored and I saw a lot of ideas from conception to execution. And it was nice to see how much focus the group of institutions, especially the engineering college, gives on innovation. And today's session, today's topics cannot be more relevant in these times where everybody is trying to come out with some sort of an invention to tackle the pandemic. Even though Sir very graciously introduced me and said that I would speak on ideas, for me, as I saw the topic in the agenda, that I need to speak on IPR in research or innovation in research, how it is being done. Now, mostly my experience has been in working with inventors and scientists and these kinds of people, and of course, musicians and those kind also. But since the past 3 years, I've been also working with educational institutions, both in India and abroad, Mumbai, Pune universities. So we're working with more than 2000 colleges. And there have been a few learnings that I would like to share with all the participants here today. The first learning that we found out that there are certain countries which are uniquely more inventive, like Switzerland, Israel, and a few others. And the reason why they are more inventive than others is there is an actual policy framework that they follow. The what I have seen in my experience with universities is most of them are following their own models based on one or two firebrand professors who try to spearhead this activity. Now, because there is an absence of policy framework, there is no uniform system that everybody follows. And as a result, the ecosystem of the universities is not able to produce some extremely credible data, which is very important to understand because most of the inventions, when they are filed by people who are under the age of 30 or over the age of 55. And this was a report given by WIPO, the World Intellectual Property Organization. And this is beautiful because it shows that you need that kind of a white space, that kind of a thinking space to come out with inventions and execute them always. So that was the thing. There was no uniformity, and there was an absence of structure, is what I saw. That when a student comes up with an idea to his professor or to his management of the college, there's no clear clarity on who will own it. Will it be co-owned? Is there an accelerator? Is there an incubator? Will there be an equity sharing? Will there be any other kind of a quid pro quo, as they say? So there is no clarity, and therefore students are also apprehensive in how much they should disclose, how much they should share, should they drop out, and so on and so forth. So these issues can be easily addressed if there is a formal policy in place. We are able to come out with a policy and we have shared it across with many universities. We will share it with DY Patil also. So I think a policy framework both across corporates and education institutions will completely take IPR and research to a next level. Because if you see the research that we publish, the papers that we publish, most of them are excellent in terms of what they bring to light.
Kunal sir.
Yeah.
Sorry for the.
The papers that we publish come out with a lot of ingenuine and inventive ideas. And here the distinction between invention and innovation is key because inventions are what are secured in IP and can be secured. So we need to track how many of these inventions really make it to the market, how many of these inventions are really brought into practice, into a prototype. And a lot of people think that IP, both in research and in practice, ends at filing the application. And therefore, you will see a lot of metrics around IP. I'm sure it must be covered in the previous sessions also, but most of the metrics are around filing. And therefore, when I visit corporates and universities and I ask them, how is your IP cell doing? What are you doing, guys, in terms of numbers? They're very proud to share about the filing statistics. When I come to implementation statistics or commercialization statistics, there is absolutely no answer. And therefore, we need to focus on whether a person is able to monetize or take his idea to the market. Otherwise, it becomes a entirely academic exercise and a CV item, which in the long run does not, I would say, it erodes the faith of the inventor in the domain of IP. So the first one was policy. The second one I've noticed across in terms of IPR and research is in terms of processes. Like I said, most places IP is person driven. It is people driven. There is some person who really believes in it, but maybe the management as a whole is not convinced, and therefore driving IP in terms of a structured process is missing, and therefore we need these kind of processes to drive it. So here I would like to mention a book, Good to Great by Jim Collins, where he tells and the innovator's dilemma, where both of them stress on the fact that unless there are processes set in place which are driving innovation, which are driving in terms of product development, we will not have any kind of serious breakthroughs because impulse based creations don't really have a long term perspective. So that was a very good insight. And coming to the third thread that I've observed, especially in academia and in research, is parameters. So there is no clear-cut set of parameters in terms of filed versus granted, CV items versus commercialized, actual versus targeted, and therefore you will see year on year there have been maybe similar inventions which are working without really any cause of major changes. Another thing that we need to understand in terms of a parameter is we need to follow or develop a culture of citations. That if we are referring to a certain published article, it may be a grade A, grade B, or whichever article, it has to be cited in a way that the person who has created it can benefit from it, both academically, commercially, and so on and so forth. And so this is, I mean, in terms of on an academic level, these three are the main things. And the difference between a few very good countries I've seen compared to what we are doing and we need to do better is establishment of these small technology transfer centers, where when we see a student or a person, an employee coming out with a potential idea which might benefit a particular industry, how do we connect him and the industry? So this is essentially the job of market adoption or technology adoption. Unless we bring this into the chain of innovation or the innovation cycle, it's going to be extremely tough. And lastly, before I move on to the generic topic of ideas, is it a part of the curriculum? Now, I teach at some of the very premier institutes, and it's fascinating. Rather, it's shockingly fascinating that none of them have IP as a core subject. Even the best colleges like IIT Bombay, for example, does not have IP as a curriculum item. And this baffles me because these are the people who are in the best position to innovate. And I'm not, say, biased toward engineers because medical school, architecture school, none of them really have IP as a core subject. Some of them do have IP, very few, the number is very few, but even these, it is very theoretical. It does not talk about filing, it does not talk about how do you say draft a claims application. It does not talk about how do you deal with objections. It does not talk about how to draft an application strategically. So you disclose everything, but in its sense, you protect also. So this kind of real industry knowledge needs to be passed on to the classroom in terms of a curriculum. And I'm happy to see that the curriculum is now being completely revamped and rehauled. And the education minister has spoken a lot about including IP. So I think we are seeing the light of the day now. And I hope it becomes a streamlined process that students as young as, say, secondary school, higher secondary, learn about IP as soon as possible. And the last thing that we should do, and I saw this especially in the Scandinavian countries, is they have specific incubators for inventive startups. So if you have a granted IP and it gives you some sort of a legal monopoly, then you are put as a part of a different accelerator process, not with other startups, because you have a competitive advantage for a period of 3, 10, 20, and in some cases almost a century in terms of a copyright, for example. And these need that special kind of nurturing. It's come to my knowledge that TIE as an organization is doing this. And I request all the policymakers in participants and in the management to think about exclusive IP accelerator for inventive companies. So that would be around, I would say, around the academic sphere that I have seen that these changes will really boost IP creation and IP deployment. On a general sense of the idea, now a lot of people are taking the pandemic in a negative light. But for me, what I've observed is a lot of my clients who could not get the time maybe to think have got that much required break and have thought of amazing ideas, right from a foot enabled hand sanitizer to many other products which I can't expressly talk about because they are in process. What I've understood is this is a good time to come out with very good prototypes because a lot of people assume that for an idea to be registered, you need to have a working testing prototype, which is really not the case, which a lot of large companies exploit. So you will notice that an idea can be registered on a provisional level also. And a provisional level essentially needs to just describe how the idea would work in terms of its backend. To give you an example of a software company, application. So one of my clients is working for an application to supply pet products. So what is registered in this is maybe his name as a trademark and his content as copyright. But what is key here is the algorithm, how the app works in the backend. And you will notice the power of algorithm is so strong that most of the companies today, maybe in the top 10 valuations, if you see the startups who are unicorns, they really don't have an asset, a tangible touch and feel asset, but they're all valued on the basis of their algorithms. I see there are a lot of speakers who are going to speak on similar subjects which are tech enabled, and you will see the value of an algorithm is so strong that the entire valuation goes down to a single piece of code. And when it comes to registering an idea, there are maybe five few fundamentals that we all need to follow. The number one is you cannot register something that's already there in the market, maybe in some other part of the country. It has to be absolutely new, absolutely original. If it is known in some part, if it is published in some part, it cannot be. And the search is pretty robust. No matter how much you try to hide it, the computer, the database will catch it. And therefore, the first advice to all who are planning to get into the stream of IP from an academic or from an industry stream is try to be on pen and paper, try to limit, try to not put your stuff on Google servers or all these public servers because they can be accessed. So that's number one. Number two is IP does not work on that's anything that's open source or something that's free. So I have seen, especially in software companies, the apps they develop, there's a lot of use of libraries which are already existing software. There is a lot of use of free open source software. Now, if you code on top of this, your originality suffers, and therefore you will not pass the novelty criteria. You cannot be using any sort of an open source. You can't combine, say, two inventions and work out. So that's not possible. So you need to be more than, say, 75% original and try to avoid anything that's open source. The third thing when it comes to IP is, like I mentioned about the policy framework, is you absolutely need to understand who will own it at the end of it. So if you are working with a university, if you're a student, if you're an employee, it's it I mean makes sense to go through the clauses of your terms of engagement and to understand that whatever you create belongs to whom, or is it a sharing arrangement. So that's very critical when we file for IP, because usually what happens, this arrangement is not clear and people really don't object at the start. But once it reaches a certain stage, once it secures funding, once it becomes market ready, then disputes start to emerge. So I would personally recommend that people trust papers over trust, so that such kind of awkward conversations are avoided absolutely at all costs. So I have had multiple experiences working with people who have come to me on an idea level, and we have registered them on a provisional level. Like I said, IP works on two stages, provisional and final. On a provisional level, you just need to describe the idea in terms of how it works on paper and register it. This can be done in an India level or an international level, and you get a time period of 1 year to work on a prototype. Now, in this 1 year, you can either choose to create a test model and create a prototype, or what you can do is you can sell it to somebody who wants to work on it. So I have seen a lot of, now, especially if you see after the corona pandemic, there is a lot of, I would say, emotional and economical malified feelings towards China, and everybody is trying to bring back their production and manufacturing. And for us to be cost and value competitive, we will have to innovate on a big deal. I mean, on a smallest of features. Which brings me to the other point that IP need not be for an entire sort of a process, but it can be for a small feature also. And I've had some beautiful experiences where people have started companies only to develop one feature, register it, patent it, and then sell it to a larger company that wants to vie for it. I'll give you an example here. One of our clients was a company called Moodle. It's a learning management system, and Moodle had developed a feature of raising your hand. Now, this feature is very common. This is back 2, 3 years back when online learning was not very mainstream. This is something that we've shifted now. So they had come out with a feature of raising your hand if you want to ask a question in a virtual session where people from all over the world are joining. So we registered this feature, and a few months later, Byju's, which is again one of the largest edtech companies, unicorns in India, came out with the same feature. Now, if we had not registered it at Moodle, Baiju had the software strength, the money strength, and the expertise to code this to add this feature within half a day. So what I'm trying to say is sometimes your entire business model need not be original or inventive. It can be just one feature that comes out as original, and that one feature can be of tremendous economic value. So that's the other thing about IP. And a mistake that I have seen now, let me give you an example that if one of my clients had created a cosmetic product and he had asked me to register this internationally, which we absolutely refused, saying that it does not make sense. And most of the other consultants that the person had hired said that we should register. So the main reason we were against registering was it was a fairness cream, men's fairness cream. And we said people in maybe the fair skinned countries won't use this. And therefore, if you're a technology product, you have to register internationally under the Madrid Protocol or under a patent cooperation treaty because technology is geographic or agnostic. It does not matter. And Uber will work in India as good as it will work in the UK, for example. But if you are a company that caters to a specific client base, it's necessary that you cover these specific geographies. Otherwise, it's people can copy you outside your home country. To give you an example, if I come out with a product invention, it's very important that I register it in production intensive countries like China, for example. Otherwise, one picture that goes to them or anything of the product that goes to them, a brochure also, they can mass manufacture it at a much lower cost. And therefore, choosing the right jurisdiction becomes very essential. This works on an academic level also, where you need to be very choosy when it comes to choosing which countries do you think your research needs to be published and protected. Because if you go for all, it becomes extremely expensive at times. So that's the other thing about IP. And another interesting example that I've come across very recently is most of the IP is class based. So there are multiple classes, there are multiple categories of IP, and an invention used in a certain class can be replicated in a different class. For example, we have all used Book My Show as an app, right? To book a seat in the movie theater, and we love the app. It's so convenient. We don't have to stand in the queues. Now, this is registered, for example, in class 42, which talks about technology products and parking and solutions and all this. But you can use the similar technology and use it for maybe say book my parking. So I can book my car parking also before I leave my house, and that will be absolutely okay. Similarly, like I said, we have some very famous brands across India, which are maybe registered in one or two class, but you can use that brand and register in the different classes. So IP works on a class front. So there are a lot of technologies currently available which can be replicated in different classes. I can give you many examples, but since the session is very, hard pressed with time, I am a little limited into sharing examples per se. So these are the various fundamentals around, say, IP in research, IP in industry. And now what I see is we are moving towards a very different kind of IP. So in the early 1970s, intellectual property was monopoly based, concentration based, where a person like Henry Ford, who developed the assembly line system and then licensed it to all other car manufacturers, and that became his primary source of revenue as well. And he had made a very arrogant statement that time that you can choose any car as long as it's Model T and it's black. So that kind of arrogance. So IP was very concentrated with people who had a lot of, say, industry influence, a lot of capital. But now what is happening is there are people like Elon Musk who have come in, who are registering maybe the core IP and the base of the IP, but opening up or keeping open source the upper development parts of it. And I think this is a very good framework that we are getting, where, for example, in case of Hyperloop, the major concept of Hyperloop, although is registered by Musk, how the it will work and the testing and the way the infrastructure is being shared in terms of coming out with a good result is kept open source. So his logic is pretty good that let's all work, let's put our collective intelligence to task and come out with a solution. Because, and I think this will breed faster innovations, and we need to follow this model rather than highly concentrated models of innovation or inventive product creation. So with this, I think I'm on the last leg of maybe 4 to 5 minutes, and if there are questions, I'm happy to take. Because IP as a subject, you can speak for days altogether, but if there are any participants or anybody who would like to ask, I'm happy to answer.
Yes, from the participants, if you have any queries, please post in the chat window. So I request Kernar sir to take over the control.
Really very good session by Kunal sir, excellent session. He thrown light on absence of structure. Basically, he's looking the, I mean, not the lacuna, but the possibilities in the academic institutions where we can go for the systematic structure, and there will be the very good industry and the institution collaboration as far as the IPR implementation is concerned. And another important point, he thrown the light on the IT courses. As he rightly mentioned, the IT courses, even the IT courses are not available in the IITs, well-known institutions. So he suggested the IT courses with practical implementation. That is really a very good suggestion. And he also given many good real-time examples how the IT industries are working, and how one can go and implement it for the real-time realization. So once again, I thank you, Kunal sir, for giving us a very informative and very good session as far as the academic, I mean, professors and the students are concerned. Thank you very much.